Your barriers, let all our right become. The Father, you take my rights away. The faster I will run. You can deny me. You can decide to turn your face away. No matter, 'cause there's something inside so strong. I know that I can make it. No, you're doing me wrong, so wrong. You were that my pride was gone. Oh, something inside so strong. Oh, something inside so strong. The more you refuse to hear my voice, the louder I will sing. You hide behind walls of Jericho. Your lies will come tumbling. Deny my place and time. You squander wealth that's mine. The light will shine so brightly it will blind you. Because there's something inside so strong. I know that I can make it. Though you're doing me wrong, so wrong. Because that my pride was gone. Oh no. Something inside so strong. Oh, something inside so strong. Brothers and sisters, when they insist we're just not good enough, but we know better. Just look them in the eyes and say, wanna do it anyway. Wanna do it anyway. Wanna do it anyway. Wanna do it anyway. Something inside so strong.
And thank you for joining us. Good afternoon, good evening, and of course, good morning, wherever you are around the world and watching us here on Linger Post. I'm your host, Mama Linger Sab. This is a series of discussions, workshops that we will be having around very pertinent issues in our society. And today we're starting with we're talking about rape and asking some very good, pertinent questions about what rape is, what the law books say about rape, our societal perceptions about rape, and some. So, what does the law on rape say in the Gambia? That's what is the topic today, and that's what we will be discussing. As we always say, Lingard Post is a safe haven, safe space for everybody. So please, let's keep our discussions, as we always do, very respectful, and our comment section also very respectful, so that we're able to elevate the discussion and be able to add value to the discussions going on. So we will appeal to you once again just to keep the space safe. We have, of course, our able panel today, and my co-host, Nene Bojang, will be co-hosting with me today. And we have on the panel today Gay So and also Madi Jabate. We are also expecting to have Tabusar, who's also coming to join us. Gay So is the Executive Director of the Institute for Human Rights and Development in Africa. Madi Jabate is a human rights defender. You've all, they are no strangers to anybody here, I think. But we'll also get them to just come on board just to introduce themselves quickly. But I'd like to hand over to my co-host this afternoon or this evening or this morning, wherever you are around the world and watching us, of course. Nene Bojang, welcome Nene to Lingere Post, and thank you for agreeing to co-host with me today.
Oh, thank you, Mama. You're doing an amazing job. It's just an honor. I had sort of retired from all of this sort of activism, but I think your energy and your drive has made it necessary for us all to come out again. Thank you, and keep up the good work.
Thank you. Okay, let's get Gay. Gay, you're welcome.
Okay, Mama, thanks for having me. At least you didn't call me Gawe. And, yes, people struggle to get my name right because always surprised to meet a guy with two surnames. So I had to tell Ndei it's not Gawe, it's Gay. I've heard some say Gay, some when I'm in Nigeria they say Gaye. But I'm happy to be here. But other than being the executive director for the Institute for Human Rights and Development in Africa, I also teach criminal law at the university. I'm the criminal law lecturer at the law faculty of the University of the Gambia. And the students just sat to their exams, I think about 2-3 weeks ago. And one of the last topics we dealt with, those who are doing criminal law, second semester, was this law on sexual offenses in this country. The Sexual Offences Act, what is rape all about in our context, as in the Gambia context, indecent assault, and of course other considerations. So I'll be happy to talk about that today. And again, like I said, thanks for having me.
Yeah. Thank you so much, Gay. Maddie?
Okay. Am I being heard? Okay, yeah. So yeah, good to be here. I think first time on Lingere show, I guess that's how you call it. Even though I've watched a few of your shows though. And good to be here with Nene, my very dear sister, And certainly I think we are all in the same hands of Gay Soy here. I think he's the expert. And as he rightly said, yes, the Sexual Offences Act would be a central, to resource and understanding all of these things. Certainly, there is also the Children's Act, in terms of issues relating to children and sexual offense. But yeah, I think it's great that we are having this conversation, and so I look forward to having an.
Thank you. I understand it's raining in Gambia, so
a debate.
It is just outside. It is raining.
Yeah. We also have in there somebody that's mute. Is that Tabu? Or is it Lala? You're on? Okay. I think we can go on then. Most prominent about the discussions that we have been having online have centered around rape, sexual violence, etc. And we thought, I try to separate my personal page and my and this space here because I believe that we have to be able to elevate the conversation at some point when we get to a certain space. And I also want to be able to have a discussion where everybody is included and involved to try and understand what the law says, to try and speak to experts, subject matter experts like Gay, to try and understand exactly what the law says and how we can navigate or have a conversation around these very difficult conversations, but conversations that need to be had nonetheless, to be able to, for us to have a greater understanding. And like I say, to add value to the conversations that we're having in other spaces. So Gay, to start off, a lot of people are saying that the Sexual Offences Act needs a revival or it needs a complete overhaul because of the issues about bail, the issues about the presumption of innocence until proven guilty, etc. Just to begin from there, Do you agree that our law books, especially the Sexual Offences Act, needs a look at in terms of some of the discussions that we're having at the moment?
Oh, okay, Mama. Thank you. Before I just go, on to talk about the Sexual Offences Act, I just would want to remind your listeners that when you talk about sexual violence, it's really not just enough for you to restrict yourself, to provisions of the Sexual Offences Act. I mean, it's important you have in mind provisions of our Constitution. Even though a lot of us have really serious problems with the 1997 Constitution, but it's important to have for you to have that at the back of your mind. Other than that, the Gambia is one of very few countries in the sub-region that has a Women's Act, which some of us would say is really progressive, targeting women, and of course, how we government should come in to make sure all women living here are given all the support they want. And in fact, that is a law going back to 2010. That's like about almost 12 years ago, or maybe more. You would have to forgive me. My maths is not so good. Other than the Women's Act, we also have the Domestic Violence Act, which was enacted not too long ago. But unfortunately, not a lot of people make use of that. But for sexual offenses, before how we had our law change in 2013, we had most sexual offenses covered in the criminal code. For those of us who are students of history, we told the Gambia had a criminal code for the first time in 1933. That's a long time ago. And in that law, the offense of rape was, introduced, created. Of course, I'm not saying before the colonialists, rape was condoned in this country, in this part of the world. But we had it introduced in our criminal code in 1933, and that you found or in section 121. And if you look at the old law before the change in 2013, that's specifically section 121, it talks about carnally knowing someone, carnal knowledge, just like in our local languages. When you want to say John had sex with Kumba, you don't say sex, you say, knowledge, So a lot of people would say that
Channel
was,
knowledge.
yes, carnal knowledge. A lot of people would say that was biblical, going back to the book of Genesis, as in saying, the man knew the woman, that kind of thing. But that kind of knowledge had to be unlawful, meaning the parties were not married at the time the sexual intercourse happened, as in at the time there was penetration. So we had that from 1933 until 2013, when our National Assembly decided to repeal and replace the law we had on rape in Section 121 with the Sexual Offences Act of 2013. Some of us feel the Sexual Offences Act is really a great improvement in the sense, the law as introduced in 2013 goes beyond just talking about a man having sex with a woman without consent to also include instances where it does not have to be carnal knowledge as we know it, like any kind of penetration, meaning, in fact, before the law was introduced in 2013, it was impossible for a woman to rape a man because the law talks about carnal knowledge, meaning the normal thing. But in 2013, that was changed. Now, any kind of penetration under coercive circumstances is punishable. I'll be happy to talk about that later. I just wanted to say, of course, if you look around in England, they had theirs change in 2005. I'm not sure there is any other country in English-speaking West Africa that has a law similar to our Sexual Offences Act, in the sense it moved beyond, what we had in 2013 to really include some very progressive provisions, as in expanding what it means to rape someone, and of course, introducing a host of issues, as in for the first time, having a law that says this is what we expect from the police when you talk about rape. This is what we expect from the prosecutor when you talk about rape. And these are also the rights of a victim of rape. We did not have that before. So in terms of law, we definitely a lot ahead of so many of our neighbors. But I can already hear people saying in Gambia, what is in the law is not always what exists in practice. But I would say if that's the problem, then we have no reason to blame the law. We have to blame ourselves for
not applying the law.
for not upholding a law our National Assembly adopted for and on behalf of all of us. So yes, your question, issues were there. You can never have a perfect law, but to be honest, when it comes to protecting women, I can't think of any other country in our sub-region that has laws maybe better than ours, from this, Trafficking in Persons Act to this Sexual Offences Act to the Women's Act, to Domestic Violence Act. There are a host of other, and even the Children's Act Madi referred to earlier on. They're really, really progressive. Probably the law ahead of what we call Gambia as we speak. But the legal framework is there. Not perfect, but a lot we can work with.
Okay. One of the things that you spoke about, I know we have a lot of questions, but I just want to make a few follow-up before we forget about that. It's the expectation from the police in terms of the Sexual Offences Act. I would just like for us to expand a bit on that. What are the expectations of the police with regards to sexual offense from the Sexual Offences Act? And if you can also just delve a little bit into the expectations or rights of the victim, and of course the rights of alleged perpetrators as well, just briefly.
Okay, if you allow me, I'm looking at the specific provisions, and I would want to read the law as it is.
Yes.
And specifically, we have Section 12. I have it with me, fortunately, of the Sexual Offences Act. It's a 2013 law. This is what it says: special duties of the police in respect of bail applications. It says in criminal proceedings at which an accused is charged maybe I need to start again. And please, if I am not very clear, let me know. This is what it says. Specifically when it comes to bail, whether somebody should be released on bail or not. This is what it says. Of course, even before you talk about the special duties of the police in Section 12, Section 11 too has a provision called special duties of the prosecutor. And if you allow me, I would read through it. It says, in criminal proceedings at which an accused is charged with an offense of a sexual nature, the prosecutor shall consult with the complainant in such proceedings. I think I need to explain. Before the solo sending judgment came out, you had members of his family complaining, even the Victims Association, that they were not notified. So a lot of them heard from the grapevine that the case was coming of a judgment. Why? Because our law as it is does not create enough room, or no room at all actually, for victims to meaningfully participate in criminal proceedings. As in, if your relative is raped, your relative is murdered, when you go to court, you don't have any special treatment. That's the law we inherited, the colonial law, which we really haven't changed. So which means you would go in and you would be treated as like any other spectator. But the Sexual Offences Act tried changing that. And Section 11 specifically says, if you are prosecuting an offense of a sexual nature, a duty is imposed on you to consult with the complainant in such proceedings. Why are you consulting with the complainant in these kind of proceedings? Section 11 tells us why. It says in order, A, to ensure that all information relevant to the trial has been obtained from the complainant, including information relevant to the question whether the accused may be released on bail and the imposition of any conditions of bail, and B, to provide all such information to the complainant as will be necessary to lessen the impact of the trial to the complainant. So in other words, it's really not about you going to the police taking your statement, telling you, yeah, we'll go back home, wait for us to get back to you. They get back to you in a month to tell you the case is coming up, please come to court. No, I mean, at the end of the day, this law makes it clear. Whatever we do, we have to make sure we go for the impact that really would be the least for the complainant. And of course, not just about impact the trial would have on the complainant, it also says the government or the prosecutor is bound to hear from the complainant, as in the prosecutor, whoever is prosecuting. And when it comes to considering whether the accused should be given bail, Section 12 goes on to tell us that the law must listen to the complainant. In other words, we know in our country, if you charge with an offense that is punishable with death or life imprisonment, that is not bail. But
Section 12.
the offense
Sorry,
charged
there's somebody echoing. Let me just try and mute everybody.
yeah, if the offense does not carry the death penalty or life imprisonment, at the end of the day, we know the court will have to release you on bail. But the law says you cannot give bail without hearing from the complainant. So I'm talking about Section 12. I'll be happy to send this law to you. And
Yes.
The court says when the court presiding over the case is thinking of whether to leave the accused on bail or not bail, the law says the complainant of rape has the right, A, to attend any proceedings where the question is considered whether an accused who is in custody on a charge of rape may be released on bail. If bail has been granted to the accused, whether any further conditions may be imposed or whether any such conditions of bail may be amended or supplemented. B, to request the prosecutor in proceedings to present any information or evidence to the court that may be relevant. In other words, if you're making a determination as to whether to release a perpetrator on bail, the law imposes a duty on you to consult with the complainant. Consult with the complainant. In other words, if you are saying you are raped or a member of your family was raped, the court cannot make a determination as to whether somebody should be released on bail or not without hearing from you. This is not the law according to Mr. Saul. It's found in Section 11, Section 12, Section 13 of the Criminal Offences Act, which means as far as our country is concerned, we have moved away from having no room for victims of rape to participate when discussions are going on as to whether somebody should be given bail. We've moved away from leaving no room whatsoever for complainants to now saying whoever is prosecuting and the court should hear from victims before the court makes a final determination as to whether bail should be allowed or not. So I think that is good progress.
Mm-hmm. Indeed. And we'll come back to that because I have a lot of questions, but I think we want to go back to base a bit. Nene, go ahead if you want to start with the first question, so we kind of just pull back on some of these issues and then we come back to it.
Thank you, Mama, for that, and thank you, Mr. Gay. But Mr. So, sorry. I think I just want to go back a little bit and start a little bit from the beginning. Mm-hmm. What can if you're accusing somebody of rape, what is rape specifically? What justifies as rape first?
I'm not sure there would ever be a justification for rape, but I would be happy to explain the law on rape in this country. Like I said, before the Sexual Offences Act, we had the Criminal Code, which in Section 129 says, carnally knowing someone, or something like that. without the person's consent, meaning before 2013, it really wasn't possible, for women to be accused of rape, but now it is possible. But let me just go specifically to your question. This is what our law, to understand what rape means in our country as we speak, you need to have a very good understanding of sections 2 and sections 2 and 3 of the Sexual Offences Act. This is what section 3 says. It says a person who intentionally, in Mandinka they say taunteya kono, and the Wolof would say tayef, intentionally. We're really not talking about accidental or you making a mistake, but I can think of a situation where someone would say the rape was accidental or whatever that is. So it says who intentionally, under coercive circumstances. Coercive circumstances, it says. Coercive as in COERCIVE. Remember, the old law talked about consent, but the current law doesn't mention sex consent. It says coercive circumstances. So it says if you intentionally are involved, under coercive circumstances with the following. That is, if you engage in a sexual act with another person, or you cause another to engage in a sexual act with the perpetrator or a third person, meaning the victim does not have to have sex with whoever he is accused of raping. You could be accused of rape or convicted of rape if you did so to a third party, as in telling a friend, go sleep with XYZ. If you don't do so, I'll make sure I beat the hell out of you. That is now covered. But what do we mean when we say a sexual act? Because the law says sexual act with another person. For the definition of sexual act, we have section 2, which says, I hope, because I know I'm speaking to a very mature audience, and I'm not trying to be vulgar. I'm going to state the law as it is. In our languages, say "kamo sutura" or "sutura."
Ani
We wouldn't
sutura
say-
te jambi abe
Okay.
ikunya di
So,
ja
okay, Abeyekoi, no problem. But remember what I said earlier on, it says engaging in a sexual act. But the law does not just stop at saying sexual act. It goes on to define sexual act in section 2. And this is what section 2 says. It's sexual act means the insertion, kafengo dundi, dugaldara, to even the slightest degree. It doesn't matter. You don't have to go deep. Even the slightest degree. They would say sometimes, chatterless, sorry for me saying that, of the penis of a man into the vagina or anus or mouth of another person. In the old law, the insertion had to be vaginal. But in the new law, anus and mouth are now included. Like I said, I don't know of any country in English-speaking West Africa that has a similar law because they continue to use carnal knowledge. But this stays in the vagina, anus, or mouth. So when we say sexual act, it's no longer about the male, female. Sorry?
And we have seen a case just recently, a medical case actually. The patient was under, I think it was under some form of medical coma or something, or she was giving birth, and a doctor actually raped her through the mouth.
So we will, in fact, we will go on to look at what coercive circumstances mean. For now, we're looking at the sexual act. There is a long list, about 9 examples of what what coercive circumstances mean. So it says, the female organ, the anus, the mouth. Before now, that wasn't possible. And then B says, the insertion of any other part of the body of an animal. So this is no longer about using the male organ. It's about using any part of the body of an animal. Like I said, I don't know of any other country in our sub-region that has this, or any object. So it does not just say you using any part of an animal. It says you using any object. You know what an object means. It could
Yes.
be whatever you like, including maybe a finger and a candle, whatever you want to call it. Any object into the vagina or anus of another person, except where such insertion is consistent with sound medical practices. Sound medical practices, it says, carried out for proper medical purposes. We'll get to that. We're still defining sexual act. And sexual act, as defined in Section 2, goes on to say, cunnilingus, cunnilingus as in oral sex, or any form of genital mutilation. So this is really broad. So it's no longer about carnal knowledge, as in using the male organ to penetrate a woman, through her organ. It's about mouth. It's also about the anus. It's also not just about the male organ, not just about the male organ. It's also about, penetrating using any part of your body, any part of the body of an animal, or any object. And it also goes on to say sexual act includes oral sex or any form of genital stimulation. Whatever you're going to use to, stimulate the genitals is now covered. So this is really, really broad. So that's what sexual activism means. But remember, I said earlier on, rape as defined says sexual act under coercive circumstances. What do we mean by coercive circumstances? The old law talked about consent. And when a circumstance is coercive, that would mean there really was no consent. But I would want to be as specific as we would want to be. There are 9 different examples of what coercive circumstances mean. And I'm going to start with A. And I think that will respond to your question and the issue Mama raised about the doctor. Coercive circumstance, if you look at section 3, sub 2, it means specifically, A, it says the application of physical force to the complainant or to a person other than the complainant, like nemo forcing it. But our law is broad. I would say progressive, because the physical force now is not only restricted to the person who is accusing the other of rape, it also includes physical force to someone other than the complainant. If you do not sleep with me, I'll kill your father. So it's really broad enough to include that. That's the first example of what coercive circumstances mean. That is A. Then B, it says threats, whether verbally or through conduct, of the application of physical force to the complainant or to a person other than the complainant. For A, we're talking about you applying force, slapping a lady, slapping a man to make him sleep with you. But then now B says it's not just about you applying force on the person, it's also about you threatening the person with force. So definitely, it says it could be verbal or even through conduct. Sometimes you don't even have to say anything. So you agree you're not going to sleep with me. We'll see. You know what I mean? So that is what it says. So it says threats to cause, to use force on the person or somebody else. I would go kill your family. That's it. Or I'll shoot you, or I'll beat the hell out of you. Then C says threats, whether verbally or through conduct, to cause harm to the complainant or to a person other than the complainant. Remember, B says you are threatening to apply force on someone. But this one is saying, threatening to use force on someone. Nima kembe butela, nima ke dinalambek. That's B. But C says not just physical force, harm. Harm is very broad. It could mean anything. Like if you don't sleep with me, I'll make sure your business crashes and stuff like that. That is what we have in C. Then D says circumstances where the complainant is under the age of 16 years. That is what we call statutory rape. So meaning every time you have sex with anybody below the age of 16, and really wouldn't matter whether the victim is a man or woman, that would satisfy the definition of coercive circumstance, because it is assumed anyone below the age of 16 is not capable of giving consent. I'll come later to what about persons who are between 16 and 18. But for now,
Yes.
our law says,
Because
coercive
I'm
circumstance.
surprised. I thought actually the law said that it was 18. I didn't realize that it was 16
No,
for
no, no, no,
statutory rape.
no, 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 no. The problem is a lot of us confuse, including lawyers, confuse defilement with rape. I'll be happy to explain. I'll be happy to explain the difference.
Yeah, we have a
Remember,
question on that.
I'll get to that. But Nene's question is specifically rape, and I'm trying
Mhm.
to explain what it means to rape someone under Gambian law.
Okay.
When we said sexual act, which we have defined, and the sexual act is under coercive circumstances. Coercive circumstances says you use force, you threaten the use of physical force, or you threaten harm to someone. Now, number 4 says where the victim is below the age of 16 years. That is a coercive circumstance. That's extremely clear. And again, let me repeat, it's not the law according to Gay. So I'm reading from section 3. Then moving on, section E says circumstances where the complainant is unlawfully detained, like you are a police officer or law enforcement agent, you arrest a guy, you arrest, a lady, you decide to have sex. That's coercive under our law. So you can't talk about, the person consenting to the sex because section 3 clearly says that is coercive. Why? Because the person is unlawfully detained. And again, it goes back to the 16 years old. You can't talk about, your victim consenting because the law clearly says for as long as the victim is below 16, the circumstance is coercive, meaning the mens rea for rape would have been satisfied, the mental elements. Then you move on to F. It says circumstances where the complainant is by 1, physical disability or helplessness, mental capacity or inability, whether permanent or temporary, intoxicating liquor or drug or any other substance which mentally incapacitates the complainant. In fact, my question to my students at the university was on this particular issue, where a lady was drugged. After she was drugged, the boyfriend decided to have sex with her, whether that amounts to rape. So it says coercive circumstance A, provided the victim does not have any physical disability, or the victim is not helpless, or the victim does not have any mental incapacity. I understand sometimes our mothers would tell you for you to get to the next position, you need to have sex with somebody who has mental issues. I don't have examples, it's just grapevine, and it might not be true. That would amount to rape going by this section. And again, this goes on to say where the victim is under the influence of alcohol or drug, that would be coercive. And 3, which I think is also interesting, it says sleep. Somebody is sleeping to such an extent that the complainant is rendered incapable of understanding the nature of the sexual act or is deprived of the opportunity to complain unwillingly to submit to or to commit to the sexual act. Like somebody sleeping, not aware of what is happening, you go on to have sexual intercourse with him, with her, that would amount to rape. So that's explained. Then we have about 3 other examples of of coercive circumstances. We have GHI. With your permission, I'll just go through them very quickly. G
Go
says
ahead.
circumstances where the complainant submits to or commits the sexual act by reason of having been induced, whether verbally or through conduct, by the perpetrator, as in about the perpetrator tricking her or him, or by some other person to the knowledge of the perpetrator, to believe that the perpetrator or person with whom the sexual act is being committed is some other person. What I used to do a few years ago, I used to bring this up as an exam question. Like now it goes off, the room is dark. I mean, the lady's husband or husband is tall. There is no light. Another tall guy walks in, gives the lady the impression I'm your boyfriend. The lady decides to sleep with the man, thinking he was actually sleeping with the boyfriend or probably with the husband. I know that's very outrageous, but our law covers that. The law says because the lady went to bed with you thinking you were someone you were not, or you gave her the impression that you were X when in actual fact you were not, that amount to rape, because the circumstances under the law would be coercive. It's super broad, super broad. And then H says circumstances where, as a result of the fraudulent misinterpretation of some act or by any fraudulent conduct on the part of the perpetrator or by or on the part of some other person to the knowledge of the perpetrator, the complainant is unaware that a sexual act is being committed with him or her. So it's about you going to a doctor, you're like pregnant or you have a problem. Remember now under our law, rape is not just restricted to women; it also includes men. So you go to your doctor. The doctor gives the impression, I need to do this to find out whether you have a baby or not. And of course, I need to make this insertion. I need to feel X, Y, Z of your body. I mean, our law now says, the doctor is giving you the impression that this is a procedure you need, when in actual fact, the doctor was falsely gratifying himself or herself. It really wasn't about whether the doctor wanted to confirm whether you were pregnant, not pregnant, whether you have an STD, not STD. It was sexual, as in the doctor doing it to gratify himself or herself. Our law says that would constitute coercive circumstances under Gambian law. So we need to be mindful of that. And finally, paragraph H of section 3.2 says circumstances where the presence of more than one person is used to intimidate the complainant, as in 5 boys in a room, 5 girls in a room. I mean, the victim thinking, if I don't agree to what this guy is saying, they might kill me. The law says that is coercive. We call that gang rape, kind of. Like, we don't have to go on to say all the guys must sleep with you. What we're saying is, if as a lady or as a man, you decide to sleep with another because you believe you are outnumbered, we're not talking about one person anymore. We're talking about 5 others. And you honestly believe if you really do not go ahead to sleep with the perpetrator, you might cause trouble for yourself. Our law says under those circumstances, under that kind of scenario, the circumstance is coercive. So, in a sense, the law has moved on. I'm really a very big fan of this law, in the sense it goes
It's very
beyond.
progressive. I mean, I didn't know that we had such progressive laws.
It's about 9 years old. A lot of European countries don't have their laws as good as this is, to be honest. And like I said earlier on, I tried doing a quick search, but as far as I know, whether we're talking about Nigeria, Liberia, Sierra Leone, Ghana, they're still, using the old law as in carnal knowledge. So the law is, I think, quite progressive. But at the end of the day, I would always say, whatever law is meaningless for as long as the people don't have the ability to make good use of it. So I think I have said enough. And I don't know whether
I think just to summarize on that, considering what is being said here, we're saying that sexual acts with a person under 16-year-old is statutory rape.
That's in section 3.
Yeah. We're also saying that if, for example, you have sexual intercourse with somebody that you drugged or somebody that's under the influence of alcohol and cannot give their consent, or somebody that is sleeping, all of those are also considered a rape or sexual assault.
Yes.
Looking at the law as well, it is saying that sexual assault does not just have to happen through sex or sexual intercourse through the vagina. It could also be through the anus or through the mouth of a person. So these are like also issues that I think that people need to be aware of. And I think someone was jokingly saying, yes.
I wanted to emphasize, it's no longer enough to, you don't have to use the male or female sexual organ.
Yes.
So good enough if you use an object or any part of your body other than your sexual organ. Thank you. Please go ahead.
Yeah. Okay. Maddie is on. We missed him.
Yeah.
Go ahead.
Yeah, I was just going to say, Mama, can he say something a little bit about, because now the legal age of marriage in the Gambia has been moved since 2016. It's now 18.
my okay. If in the draft that was submitted to the National Assembly, marital rape was included,
Yes.
but we're talking about 2013. But the National Assembly decided not to pass that. So the section I just read, section 3, has a subsection 3 which says, for the purpose of this section, rape shall not apply to married couples. So
Oi.
as we speak, there is nothing like marital rape in this country. It's not for me to say whether that is good law or bad law. I mean, those who know me well know my views on this. But as we speak, you can't talk about rape where the couples are married. But I can tell you, in the
Wow.
draft that was submitted to the National Assembly,
Yes.
marital rape was included. But the law that was passed by the National Assembly decided not to have marital rape included in the definition of rape. That is in section 3, subsection 3. And let me read it again. It says, for the purposes of this section, you heard me read all of it, what it means, causes, circumstance. Rape shall not apply to married couples. I'm
Wow.
sure.
That's in the Gambia.
Um,
But the legal age of marriage in the Gambia has been moved to 18.
Yes.
Yes. And that was in 2016. Because
Okay.
that's what was reported to the expert group.
Yeah. Which means if you have, but I mean, at the end of the day, the law goes on to tell you if the victim is below 16, that is rape. So you can't, you're not, I mean, presiding as a magistrate or judge, I won't let you use the defense of marriage because the law makes it clear if your victim is below the age of 16, the circumstances are coercive. But then some of us would say that's not the reality on the ground. But I mean, at the end of the day, why do we have to, enact a law for the sake of it? If we did not believe in this issue, why did we have to have it passed into law? The law is extremely clear. It says if the victim is below 16, the circumstances are coercive.
wow. Gay, just as Coach Pasambajau is saying, he has a problem with Section 3, which seems to exclude marital rape, which means married women are not safe.
Yes.
Wow.
Thank you.
We all do, but as we speak, that is the law. In class, my former students already know what my views are on this, but at the end of the day, that is the law. If we don't like it, we have to change it.
That's why somebody was telling me, no, there's no such thing as no when you're married. So he knew what he was saying then. I'm like,
he was
but
right.
I was, yeah, he was
He
right.
was right.
Yeah.
Wow. Okay. Wow. Somebody else is saying, and I think we need clarification on this because it's also very important that we get clarification or we at least make it clear to the people that are watching. Somebody else just made a comment about this, and she said, even if the minor says yes, so even if somebody under 16 says yes, and consents to you having intercourse or sexual relationship with her, it is still rape in the eyes of the law. Is that correct in my understanding or not?
100%.
Yes.
But we have a problem. I would explain. In fact, I recently was having a similar discussion. I have a good judgment from Botswana that really distinguishes, defilement from rape. In our country, when you hear a lady was defiled, defiled sounds really, really crazy. Kind of, ima rape, yeah, defile, rape in Kodenko defile. But rape is more serious than defilement. So when you talk about rape, age does not matter. Whether the victim is 100, whether the victim is 50, whether the victim is 18 or 10 or even 2 years old. Remember, of course, the law says if you're below 16, it's coercive. It doesn't matter the age. For as long as the sexual intercourse happened under coercive circumstances, the offense of rape would have been made out. But because of how defilement sounds, because I have heard people saying, oh no, the alleged victim wasn't a virgin. Virginity isn't a defense to a rape charge. The court is not going to look at whether you were a virgin at the time you had sex. When I finished sixth form, I worked in the courts before I went to study law. And I remember, my boss at the time presiding over a rape case involving a Senegalese. And I remember the Senegalese, his defense always was, the girl was young, but she wasn't a virgin when I slept with her. That's not. It's about you having sexual intercourse with someone without under coercive circumstances. So age is irrelevant. The only time age is relevant is where, for example, we're talking about the victim is being under the age of 16. Section 3 says, under those circumstances, under that kind of scenario, the circumstances are coercive. But let me make my point. We have seen people who should have been charged with rape, charged with defilement. If you look at the same law, I'm trying to find it now. Give me a second. I'll get to it later. Just a minute. I'm trying to. Please bear with me.
Whilst you're looking for the section, let me just read some of the comments here so that we can maybe address those as well. Coach is saying here that the dangers of Section 3 is that many couples, though separated, are still considered married. Therefore, one can rape a separated partner and still use marriage as a cover. So that's one of the reasons for that. Yaifal also said something about Sharia. And this was an issue that a lot of us raised. The 1997 Constitution, she said, recognizes Sharia as part of the laws of the Gambia with regards to marriage, inheritance, and divorce. And in Sharia, marriage could be at 9 years, meaning that raising the marriage to 18 could be unconstitutional based on personal law.
I tell you, I agree with Coach. In fact, I used to bring it up as an exam question. I would always, John married to Kumba. They have a problem. Kumba moves back to her parents' house. John decides to go back to have sexual intercourse with Kumba without her consent, whether that amounts to rape. Under the law as it is, that cannot be rape because they're still married. They're not yet divorced. Please tell Coach, I know he's a good friend. I am with him. I understand where he's coming from, but I'm really stating the law as it is. I'm not trying to justify it. I think that is good law. It's for your audience to decide on whether that law is so terrible, we need to change it, or the law is so good, we need to keep it. But as I speak,
no, it should be changed. It's what's good about it.
Yeah, so we have one vote for a change from Nene, which is a good thing.
Not one vote, we have many votes.
No, we heard from you now, so probably we would have to do a campaign later. But I have heard the thing
just
about it.
The issue of Sharia and marriage and
no, the thing is, listen, I don't know. I know Yai, and he knows I know him. We have nothing called Sharia criminal law. In the Gambia, when you steal, people don't call for your hand to be cut off. Section 252 says you have to go to jail for 5 years. Sharia doesn't apply to criminality. And our criminal law says if you have sex with anyone below the age of 16, and it doesn't create any exception. If the law was to go on to say, provided, of course, if it is done under Islamic law, that is a defense. You know what I mean? Our law goes on to say, if you have sex with anybody below the age of 16, the circumstances are coercive. That is what it says. Like I said, what I would have preferred? I'm not sure, because I would have loved to have all these things projected so that with your audience, we'll have a look at all of them one by one. So, yeah. So I don't like it when people look for excuses. If you don't like the law, change it. But as I speak, that is the law. we need to apply.
And,
But
and,
let me
and,
go back to your
and
question.
definitely, I think it's very, very actually dangerous to try and use religion as a defense for rape. So I definitely, or
Yeah,
defilement as we call it. Let's get quickly into
yeah,
defilement, Gail.
yes, yeah,
Exactly.
because
Yeah.
I know the police make that mistake. Sorry, and I know a lot of us make that mistake, and I would be happy to clarify, because you know the way it sounds. Defilement is, if you look at Section 5, the punishment for defilement is, it says a person who unlawfully has carnal knowledge. Carnal knowledge is creeping back in. I'm not a big fan of that word. Or to a conviction to imprisonment not exceeding 7 years. That's defilement. But if you look at rape, the lowest you get if you're accused of rape is about, is it 15 years? Under certain circumstances, like where the victim is below the age of 16, where you infect the victim with a sexual disease, sexually transmitted disease, our law says the punishment for it is life imprisonment. The circumstances I will explain. So, what is defilement? Rape is sex under coercive circumstances. And like I said, you don't have to use the male organ. Defilement is carnal knowledge, meaning sex. But here we're saying the victim is between 16 and 18. But why is defilement different from rape? Defilement is where the perpetrator is trying to say the victim consented to the sex. You know what I mean? So, from what we know already, if the victim is below 16, that's rape. But under Section 5, if the victim is below age and 16, because the age for consent in our country is 18 years, if the victim is below 16 and 18, and the accused person is saying, the girl I slept with consented or agreed to me sleeping with her, the law is now telling you, even though the girl might have given her consent, but because she's under 18, instead of having you convicted of rape, which under certain circumstances attracts imprisonment of about, attracts life imprisonment, we're saying, because you're saying the victim consented, we still wouldn't let you go scot-free, because the girl is only 17. She wasn't capable of giving a genuine consent. As a result of which, because you're relying on consent, meaning the circumstances is no longer coercive, instead of having you charged with rape, we will have you charged with defilement. So defilement comes in, one, when we're talking about the victim being between 16 and 18, under 18, but above 16, and two, where the accused is trying to say the little girl agreed to me having sex with her. Because the victim is no longer below 16, and you're saying she already consented, the law is saying instead of having you charged with rape, we'll have you charged with defilement. Unfortunately, what I see happen, I see it reported in the papers. What our people do, like if somebody is accused of having sexual intercourse with a 10-year-old, they have you charged with defilement. That is 1000% wrong. In the sense, if you have such a guy charged with defilement, the maximum he would go away for is 7 years. Why do you have to do that? When the law already makes it clear, if you're below 16, consent is no longer an issue. When the victim is below 16, the circumstances are coercive, statutory rape. So we talk about defilement where a victim is above 16 but below 18, and the accused person is contending that the victim consented to the sexual intercourse. So the law is saying, yeah, because the girl is 17 and there is evidence to show she consented, at least she agreed to whatever you did, instead of having you sent away for life, we would have you sent away for 7 years maximum. Meaning, if the girl is 17, even though if that is consent, you still would be charged with defilement. I hope that was clear. And I hope I didn't sound too much like a lawyer.
No, it was very clear. Very clear. Mama, go ahead. It was very clear. Thank you. Mama, you're mute. You're mute.
Thank you, Nene. So just to continue quickly, we have so many questions. I don't know if we will get through all of them. Madi, we seem to have lost, but we will try and get him here again. Just quickly, Gay, is there a difference between sexual assault and rape under Gambian law?
A lot of people use sexual assault in very broad terms, and we use it to include. I know in England they have rape and they also have something called sexual assault. But in the sense, sexual assault in the sense there really isn't any kind of penetration. It could mean indecent assault, etc., etc. But when you use sexual assault, it is broad enough to include indecent assault. It is broad enough to include rape. It is also broad enough to include defilement. So here we're talking about there being, sexual act, as in contact that is sexual, and the victim not agreeing to that kind of contact. So it's really, really, really broad. Because, like I said, broad enough to include any sexual offense you might think of. Yeah, but our law specifically has rape, it has defilement, and of course, it has other offenses. So you are correct if you define sexual assault to include rape, to include defilement, or any offense we might have covered in the Sexual Offences Act, because it's about a touch that wasn't consensual, that wasn't agreed to by the other person. Whether it was penetration, no penetration, it's still sexual assault. The touch wasn't authorized. Yeah, so it's broad enough to include all that. But just to say, we have absolutely, like we have rape, we have defilement, a host of other offenses, but we don't have something you can specifically call sexual assault. Like I said, it's a very broad term. Just like when you say sexual violence could be beating, it could also mean sexual intercourse without consent. So it does not just always have to be sexual, like you beating your partner 24/7. That's sexual assault. You having sex with a girl under coercive circumstances, or a girl, penetrating a guy under coercive circumstances. That is still sexual assault in the sense the touch wasn't authorized. It wasn't allowed by the victim.
Okay. We talk a lot about victims, but there's a very interesting question which I think maybe we can also ask. What about when two minors are involved? What is the law's position, for example, if two minors are involved and still parents decide, for example, to launch a complaint at the police that their child, whether the male or the female, was raped because they're still a minor by this other child?
Okay. The age of criminal responsibility in this country is 12 years. Meaning, if you below the age of 12, you're not capable of committing a crime. So if you interpret minor to mean like an 11-year-old, being accused of rape, then that 11-year-old does not bear any form of criminal responsibility in the sense the 11-year-old is below the cutoff point. But if you above 12 but below 18, the law does not give you immunity because you are a minor. If a 13-year-old rapes, it's still rape, and it really wouldn't matter who the victim is. If a 16-year-old rapes, it is rape. It also wouldn't matter who the victim is. The law would apply. The only difference is if we're talking about someone above 12, below 18, being involved in criminal activity, the only difference is the procedure. So the substantive law remains the same, meaning rape is rape, irrespective of who the perpetrator is. But the procedure is different in the sense, if a 16-year-old is accused of rape, you don't drag them before the High Court. You have to take them to the Children's Court. And the law that applies to them is different, and because they are children, in the sense you wouldn't see their names in the papers. And of course, other measures the court has to put in place to make sure they get a fair trial. So, rape is rape for as long as the perpetrator is above 12. But if the perpetrator is above 12 and below 18, then the procedure is different. So, for example, if a victim is 16, 17, you can't have them arrested dumb at mile 2, or have them to mix with adults, or take them before the High Court or Magistrates Court. There are special processes where minors are involved. And I think our law is extremely extremely clear. So in a sense, what I'm saying is rape for as long as the perpetrator is not below 12. But if we're talking about rape perpetrated by persons above 12, below 18, then you can't really proceed with them the way you would proceed with an adult. That doesn't mean they have a defense. When they go to court, they're going to be set free as if they did nothing wrong. That's not the law. Just that, like I said, you have to tread with children very, very carefully. Take them to a special court, and the procedure wouldn't be as tedious as if it was a man, an adult charged with rape. So I hope that answers your question.
Mama, you're muted.
Sorry. I know a lot of people are asking questions or in the comment section. This one, Maricham, families, instead of protecting the victims, they will protect the assailants or the perpetrators. And when that happens, Gay, is there any provision in the law in terms of protecting victims? I know you talked about the rights of the victim in terms of being informed, especially when it comes to the issue of bailing an alleged perpetrator. But what are is there any provisions in the laws of the country in terms of protecting victims, even within, because we've seen in some cases where even the complainant or the victim is afraid to attend sittings because of certain issues around security, etc. What is is there any provision that would guide in terms of what the police or what the law can do to protect that victim?
Yeah, thank you, Mom. I think that's a good question. But one of the biggest problems we have in our criminal justice system is a lack of participation for victims of crimes. We thought when we revised the criminal code, and the criminal procedure code, that we introduced provisions that were good enough. But reading the report of the TRRC, following the Solo Sanding case for years, I'm beginning to ask myself whether what we have on victim participation is broad enough.
Mm-hmm.
It's been one of the biggest failures of our criminal law as inherited. Like, if a relative of yours is killed, if a relative of yours is raped, what you do, go to court, and you're treated like, everybody else. No special consideration, nothing, absolutely. So I think this is something we need to take. If you're following the bylaw trial, the Hyderabad family have a role. In fact, they even have a lawyer advising them. But that is not how it is.
Mm-hmm.
When you go into, if you're talking about a rape case, the victim's family cannot just go to court and talk. The court will start, who are you? You're not a witness. And in fact, our law is such that when a witness is testifying, other witnesses are asked out of the court. So this is a law we put in place in 1933. I mean, we're talking about 2022. Do we continue to live our lives that way? Meaning, even though we know it was your mom who was killed or your relative who was raped, when you go to court, you have no special considerations. You're treated just like everybody else. Do we need to live our law that way, or we need to move on? Because, for a lot of victims, this is a form of healing. I went to court, I vented. The court heard me. They gave me a role. at least I was important. I was able to, explain all that has been. But unfortunately, as we speak, we don't have that kind of role in the state for victims. So maybe that then would call for room for more changes in our law. But like I said, as we speak, remember, even the draft bill before the bill before the National Assembly, has been at the National Assembly for 3-4 years, I think, or even more. So the question would be,
but can a victim engage the services of a lawyer who will also act in with the state, or at least in collaboration with the state?
We have, because in the Gambia, maybe more than 99.9% of our cases are prosecuted by the state. Our law provides for providing private prosecutions. Like if you have the means as a victim, if you feel the government is not taking your case properly, nothing stops you from filing a private prosecution. That is allowed. The law mentions private prosecutions, but the details are not there. We tried changing that in the law that is before the National Assembly. But then, other than going for the criminal process, as a victim, nothing stops you from going to court to file a case seeking for damages from the perpetrator. So that too is another option. As in, you feel government not doing enough, you feel wronged, you can always file a civil suit that would enable you to recover damages. But a lot of women would tell you, rape is not always about giving somebody tens of millions of dollars. It's sometimes about correcting the wrong. Whether what we have is good enough is another question.
So you can file a separate suit, but maybe going and having your own lawyer assisting the state lawyer is something else.
No, but having your lawyer, because at the end of the day, even if your lawyer goes to court, the lawyer does not have any particular rights. You can go in, you register as a friend of the court, assist the court, but you really are not formally part of that whole process, which is why I said is a gap in our laws, which we definitely need to look at. Because like I said, for some people, it's not just about sending the accused person to jail. They want to be heard. They feel wronged. They just want to vent. Our law does not allow that opportunity, other than going to court to testify. The opportunity isn't always there. So that's something we need to take a look at.
We have seen, I know that most of our very high profile cases around sexual assault are also tried a lot by public opinion. And sometimes that public opinion does have ramifications on cases, etc. My question is, does the law protect victims against this public vilification or alleged victims, I would say, from public vilification or any sort of protection in terms of anything outside of the court? Is there that kind of protection?
I would say, of course, we all have a right to freedom of expression. And protest, demonstrate, speak is allowed. I think that was what we all wanted. But your rights stop where my rights begin. In as much as you have a right to demonstrate, you have a right to express yourself. I also have my right to privacy. I also have my right to a remedy. If I feel wronged, our law makes it clear I have the right to go to court to seek redress. Whether our courts can do enough to put a stop to what you described, or whether the laws are wide enough to put a stop to what you described, I'm not 100% sure. But in law, we have a principle. That was why when Nene reached out to me, I made it clear to her I really wasn't going to come on to talk about.
We cannot speak about current cases before the law.
Because we say in law is sub judice, is before the courts, and that would mean as a lawyer I cannot comment. But we also have to be mindful of what I always tell my students: the law is meant for us, not us for the law. If you feel applying a particular law might lead to probably injustice or whatever. I mean, I think if the court is aware of such information, nothing stops the courts because it's about justice. And, we told justice is a three-way street because we're talking about justice for the perpetrator, justice for the victim, and justice for society. If we feel any of those is compromised, probably, people commenting on the substance on a case that has not or that has not yet been decided. I think that is something whoever is presiding should be allowed to look into. I mean, if you feel probably that the way things are going, somebody's right to fair trial might be compromised, I think it's your responsibility to correct that. I can give an example. Um, actually, I think I was the lead lawyer for that case many years ago. My case worked on a case against uh, Ethiopia on behalf of the former prime minister of that country, who, if you are a student of history, you would know Mengistu Haile Mariam. I think he now lives in exile in Zimbabwe, was accused of very serious human rights violations. And after he was kicked out of office, he ran to Zimbabwe. But the government that took over did. They invited senior members of his government to report themselves to the police. They did, but they were held in pretrial detention for 3 years before they were taken to court. And when they were taken to court, they were charged with all kinds of crimes, from genocide, crimes against humanity, torture, etc. So they were held in pretrial detention for 3 years before they were taken to court. And their trial dragged on for a period of about 16 years. We were invited, we got in, and our submission was holding people for pretrial detention for long periods of time means you're violating their right to presumption of innocence, and allowing their trial for drag on for 16 years is outrageous. So, in a sense, what I'm trying to say, it is the responsibility of whatever court is dealing with whatever criminal matter to make sure the victim gets justice, the accused person gets justice. And at the end of the day, if you feel too much is going on, that is really making it impossible for you to do justice in the case, then you have to find a way of making sure that it's sorted out. Like I said, like, don't allow interferences. Of course, we know the judges, the judiciary, they're human, but at the end of the day, it's their responsibility to make sure they uphold the law at all times. Justice has to be done, even if heavens fall. So if there exists anything that is making it difficult or impossible for you to do justice, you really have to make sure you address that. Yeah. But that would mean, of course, you doing what is right, and of course not being under the influence of, now social media is very, very powerful, but just to make sure you at least proceed, do the right thing. I don't know whether that responds to your question.
Nene, I don't want to know if you want to ask some questions before I continue. I have a few here.
Yeah, do you have comments, or do we just go on from
go ahead.
Okay. We're saying that in the Gambia, or in the Republic of the Gambia, that rape is not, it can't be bailed. You can't be bailed unless the judge uses his own discretion. I mean, what would allow, what type of factors would the judge consider when deciding bail?
Okay, thank you. I think our law is very specific on bail. Of course, there have been questions as to whether what we have in the Criminal Procedure Code on bail conforms to provisions of the Constitution. But, I mean, as we speak, there is a valid law passed by the National Assembly which says if you are charged with any offense that is punishable with death or life imprisonment, you cannot get bail. That is the law. But we know if you don't like the law, what you do is challenge it. If you feel that law is unconstitutional, what we require from you is to go to court to get the court to declare that law unconstitutional, which hasn't happened. Which means, as I speak to you, if you're charged with any offense that provides for the death penalty, or life imprisonment as a penalty, you cannot get bail. And just like I read out earlier on, rape in specific circumstances attracts life imprisonment as a penalty. So at the end of the day, you can't talk about the judge exercising a discretion when the law specifically says if the offense the accused is charged with is punishable with life imprisonment, you cannot give bail. Judges are meant to uphold the law. Like I said, it is the responsibility of the National Assembly to change that law, or the responsibility of any of us who has a problem with that law to go to court to have it challenged so that our courts will declare the law unconstitutional. But as we speak, I'm not aware of any law challenging that provision, which means legally, under our law, whether it's about murder, whether it's about manslaughter, whether it's about rape in specific situations, for as long as the penalty is death or life imprisonment, no bail for you. And those of us who were here, particularly on when we had Jammeh as our president, we remember that used to be used a lot, which was why anytime there were allegations of people being accused of being involved in a coup, people would begin to run away because all they needed to do is have you charged with concealment of treason. Like somebody told you he was going to do a coup and you said nothing. You remember the Tamsir Jasings, the Mariam Dentins, and others were charged under that law. And a lot of them were held in custody for a period of about 100 days. They couldn't be given bail because the law says so. Yeah. Bad law, good law, we have a National Assembly. I personally think, because if you look at the law as revised before the National Assembly, we decided to move away from that, as in saying, even if the charge is murder, like in America, if you charge with murder, you can be released on a bond of about 10 million, 5 million, or whatever that is. We're trying to say now, how about we leave it to the court's discretion. In deserving cases, like it doesn't matter whether it's rape or it's, the murder. In deserving cases, the court can think about giving bail, but that is aspirational. The law is before the National Assembly, not yet passed. So until that law is passed, under Gambian law, any offense that attracts the death penalty or life imprisonment is not bailable.
Okay.
Thank you.
Do you want to ask any other questions? Nene?
No, Mama, just go ahead with the comments and the other things. Yeah.
All right. Okay. Ami is also asking here, do we have any mandated reporter laws, i.e. doctors, teachers, caregivers, nurses, etc., required to report abuses on minors, including assaults and rapes? Because I'm not sure we have a structure in place that actually does this, or I'm not aware of it, even if it's stated in our law books.
Okay. Which army is that?
Cisse.
Hello, Pankavik. I haven't seen her for ages. It's okay. Okay. What we, we have to understand a bulk of our criminal law is as inherited. And unfortunately, in this country, we don't have good Samaritan laws. Let me explain what I mean by that. If I'm walking along Carava Avenue and I see a boy about to be crushed by a moving car, and I can easily save the boy by just stretching my hand and, pulling him off the road. If I fail to do that, and unfortunately the boy is crushed, there is nothing you can do to me. It's immoral, like those of us who are Christians would say is a sin of a haram. But there is absolutely no obligation imposed to save a life. I think it's important we understand that, but that's the rule. And as we would always say, for every general rule, there is an exception, which is why if you look at our criminal code, some exceptions are created, like 18, Section 18, Section 19, Section 20, Section 21. And in fact, some of them developed by the courts over the years, like saying, if you're in a position of responsibility, like you are a family head, or you are a child's parent, you cannot sit by and watch your child suffer any kind of harm. That's really, really clear. So going back to her question, of course, as a doctor is in a position of responsibility. And we, of course, would all agree the doctor would owe that same kind of obligation to his or her patients. So if the question is whether when the doctor is aware, he is supposed to respond to the authorities, as in report the matter to the authorities. If her question is about that, a doctor knowing and deciding to stay quiet, because a doctor-patient relationship is protected, is privileged, meaning the doctor is in a position of responsibility. The doctor cannot stay quiet because of the responsibility I talked about, like voluntary assuming somebody's responsibility. That is, if that is what AMI means, I hope that responds to her question. But I also wanted to emphasize, if you look at Section 367 of our criminal code, it makes it clear if a felony is committed in your presence, a felony normally we would say is uh, um, any crime that attracts imprisonment of more than 3 years. If somebody is committing a felony in your presence, you must do everything reasonably possible to make sure you put a stop to it. 367, neglect to prevent a felony. So if a doctor is committing a crime, your neighbor is committing a felony in your presence, any crime that attracts imprisonment of 3 years, you cannot stand by and watch. You have to intervene if you can. But of course, that doesn't mean you have to put your life in danger. So, in a sense, if it is about a doctor who is aware of somebody being caused harm, I mean, his patient being caused harm, her patient being caused harm, then the law requires the doctor to do something to save the patient. But at the end of the day, if it is about a doctor, the neighbors, somebody being committing a crime, the law also imposes a duty, an obligation on the doctor to do something to make sure whatever the other had in mind is stopped. I don't know. I don't want to sound too, but I hope that responds to Ami's, question. But important for us to have at the back of our minds. Yep, we don't have good Samaritan laws, as in your neighbor's house burning. You don't have to rush to your neighbor's rescue. If in fact, throw a party the next day after the house was burned to the ground, that wouldn't give rise to any form of criminal liability. That's our law. It's immoral, it's haram, it's a sin, but the law does not say we can come after you.
I think, Mary, that kind of answers the Good Samaritan law that Gay was talking about, because she's asking if family members can be held accountable for knowing about an incident of abuse and not reporting it. I think that you covered just now with the good, in terms of just there's no obligation on the person to report the case in terms of them being criminally liable. Am I right? So that we can move. Tufa is also here and she wants to ask a question.
As in, no duty.
So,
If
for example, is aware of a child being sexually abused,
if who is aware?
Is aware of a family or a child being sexually abused within the family, and the family member does not report that. Is there
That's
any
a
law?
special relationship. Oh yeah, there is. The relationship is special. Like I said, I remember I chose my words carefully. I'm running, I'm walking along Carava Avenue. Somebody at meeting for the first time. If it was to be my child, I can stand by and watch, or maybe a family member, because under the circumstances, we would say the relationship is special. Whether you're in a position of responsibility, or you are a parent or a family member, that kind of relationship is provided for, special.
Okay. So there's an obligation on the family member to report incidences like that, for example.
Oh yeah, you can stand by and do nothing. Yes.
Okay. Tufa, go ahead. Do you want to ask a question?
Yes. To Mr. So, I think going back to the idea of public opinion, what I wanted to ask, and I think there is a huge misunderstanding within the Gambian populace, especially just in the local communities, the idea of who's prosecuting whom. When you hear often tufa mungeyo buki court, tufa mungeyo buki through the legal process. If you could explain to us what is the relationship between the prosecution office or the prosecutor and the complainant within our system, because I think a lot of people don't understand how a lot of families, especially when it comes to SGBV, are frustrated by the fact that they are only seen as witnesses in their cases, how there's no obligation to keep them updated, where they're not told when court dates are. I think you have indicated that. But a lot of people will assume if there is a case where I am the complainant and then there is an accused, that there is this personal responsibility of me taking the person through the courts. If you could just please elaborate on how our courts are set up, and especially the relationship between the prosecutor and the complainant. How does that work? Yeah.
Okay, thank you. I'm sure we all understand we in this country have the common law system, in us, inherited from a colonial master. Oh, yeah. But let me start by saying, when you do, when it comes to criminality, one other thing we have to have at the back of our minds is crimes are not private wrongs; they are public wrongs. It's very much different from Mr. Mr. So saying, "I lost my dog," or "I lost anybody who finds it, I'll give you $5,000." So if you find my dog, law of contract says I would need to pay up. That's private. If I refuse to pay up, you can take me to court to get your $5,000 back. That's private. But criminality is way beyond that. If you want to be too academic, people would say, like there being what they call a social contract. You want to be part of this place called Gambia, and for as long as we live here, we want to be governed by laws. We want to be governed by rules, and we have elected or appointed certain officials to certain positions, as in for them to do the right thing on our behalf. So when I talk about a crime being a public wrong, what I mean is the enforcement of criminal law is everybody's business. Meaning, if somebody steals from me, it is no longer just Mr. Saul's business. It is everybody's business. If somebody commits rape, it's no longer just Mr. Saul. It's everybody's business. Murder, And unfortunately, sometimes the way we react, we do so without realizing. You had somebody committed murder, he was sentenced to death. You would hear people saying, then komoy. That's our reaction. Why? Because the enforcement of the criminal law is our business. So, having said that, we then would proceed to say, because a crime is a public wrong, if theft is committed, rape is committed, murder is committed, when it comes to making sure justice is done, that right to make sure there is justice isn't just available to the victims and members of their family, which is why when rape happens, when murder happens, you will report to the police. The police are paid by us. They will do the right thing. And at the end of the day, after they investigate, they will go to court. They will get a prosecutor. The state law office would get a prosecutor. And of course, there would be a magistrate or judge. All of them we pay. Public wrong. Everybody's business. So if it is about
after the report at this point, it is the state. It is the state versus, or is the state with both cases? Is it?
Yeah, I know. Yeah, I'll get to the latter bit as to whether what we have is good enough. But after you report, the way our system is, if you have been victim of criminal activity, whether we're talking about rape, murder, theft, All that the police will require from you is for you to give your statement. And then after they would tell you, Ninsula Taylor Mbeku Mandela, Sunila Sohla Nangla, or when we want you, we would call you back. You go back. Sometimes you wait for a while before you're told where your court is going to, when your case is coming up. But that's just one aspect of it. As in, whatever the state does, it does on your behalf. Whether through the police, through the state law office, it's done on your behalf. But our law goes on to allow what we call private prosecutions. You do not have you don't have to be a victim of a crime to file a private prosecution. It's just mentioned in our laws, but not fully developed, which is why in the law before the National Assembly, we decided to add a lot of meat on that. So now to your issue, there is rape, there is murder, there is theft. As we speak, when you go to court, all that you are to the court is a witness. Even if you're the victim of rape, the court would invite what happened to you. And in most cases, if you have been, watching rape cases, you see the victim is subjected to very rigorous cross-examination, placing all kinds of doubts, that kind of thing. So all that you are is a witness. So you go, you testify. When you don't testify, you'll be cross-examined. And after that, the court will ask you to go, nothing else. The question now is, how proper is that? The law as we have it, does it lead to proper healing? How about we change our law to make room for victims to vent? Like when you're talking about sentencing, making room for victims to address the court as to the kind of sentence they believe the accused person deserves. Or if the victim needs psychological support, victim traumatized after the rape, not having any support, for the victim to make submissions to the court. Since this happened, I have been finding it impossible to sleep at night. I need counseling. How about the state providing me? Unfortunately, our law does not go far enough to cover all those instances, which is why a lot of people have been calling for the law to be changed to make room for victims to have a say. So it's not just enough, like we have in our code, for us to say, yeah, when it comes to deciding when a case is to be adjourned to, or whether the accused should be released on bail, the victim should be heard. Is that good enough? What about the victim participating in the whole process, from the time of arrest to the time of testifying to the time of sentencing? Like I said, our law does not go far enough to cover all those stages.
Yeah,
What do we do?
I believe the myth, actually, that's what I started with. The myth or the concept for most of us, for the general populace, is actually that there is a huge belief that the complainant actually plays a great role and participates more directly than it actually is. So just a question, I mean, I'm more a tighter one to this.
Can I,
There is a
before you,
rape case. Yeah, there is a rape case, and then I say Mama Linger Sar, let's say in this case is the complainant. The notion or the sentence to say Mama Linger Sar is taken Tufa Jallo to prison, Mama Linger Sar has taken Tufa to jail. Is that accurate under this setup, under this current setup?
no, from what I explained, that's not possible.
Okay.
We all know in our country, I mean, I'm Gambian, we all are, how proud our people are. If somebody is arrested, even if the victim is probably your child or maybe your family member, you go to police, 24/7, telling them, do this, do that. They will blow up. Who are you to tell me? You're so leggy that one smaligay. Those of us who are familiar with the way things run in this country would tell you that is accurate. At the end of the day, the victim is, under our law, is only a witness, which is why if I steal $100 from Tufa and I'm arrested, unless of course Tufa decides to take me to court to recover the $100. But if it is a criminal trial, I'm arrested, I'm prosecuted. The matter is never called Tufa versus Gay Soul. If it is at the magistrate's court, it is called the Inspector General of Police. We pay the IGP prosecuting on our behalf. Because if you want to say everybody in this country is prosecuting Mr. So, probably you might have a document that is 100,000 pages long. So the Inspector General of Police does that on our behalf. And if it is at the state law, if it is at the High Court, you have the state versus Mr. Gay So. That is what you have in Nigeria, what you have in Ghana, what you have in the US. In England, they say R as in the Queen versus whoever that is. Why do we say the state? Why do we say the IGP? Because whoever is prosecuting is doing so in your name, in my name, in the name of all Gambians and all those who continue to live here. So, I mean, for those of us who have been victim of crimes, when you report the matter to the police, all that they will require you to do is like give a statement. When you give your statement, you go home. If you want to stay to tell them what to do, I'm sure you wouldn't go home normal, because they will tell you, hey, I'm the expert here. I'm doing my job. It's not for you to tell me what to do. This is my area. I mean, and you know, our people, we don't like being told what to do.
Yeah, thank you so much for shedding light on that. I think there needs to be a lot of local, just trying to water this down so that it is really understood, because our idea really is gay so dafa yóbbu Tufa to jail daf ko tëj moom moo ko tëj. You know, there is a lot of personalization when it comes to cases, and that takes away that idea of state versus this person is completely thrown out of the window. I mean, within the educated group or people that are very vast in the law do understand that, but majority of the general public really do believe that an individual takes someone to jail or someone is in jail because of your width or your capabilities and abilities. So thank you for clarifying that.
You can say Gay-Sow is the complainant. Gay-Sow filed the case. I was a magistrate for 8 years. Oh man, I can't imagine anyone coming to my court to tell me, Mr. So, send this guy to jail or let him go. If you do that, you won't go home to your family. That's disrespectful. So what you do, you are just a complainant. You know, you complain and the state would decide to take the matter further. But some of us are now saying, is it fair for the victim of a crime to be a bystander in a case involving him or her? Is that justice? When all you have from the victim is a witness statement. So that's the question. But like going back to your question, as we speak, you are just a complainant. You will file the case, and of course the police will do the needful, the Ministry of Justice will do the needful, and of course the judge will do the needful. Whether the prosecutor, the lawyer from the Ministry of Justice, or the judge do the right thing or not, I don't know. But at the end of the day, your role maybe is more or less like a bystander. You cannot dictate to the court as to which way this case is going to go. Whether that's good enough or not, I'm sure is something Gambians should start talking about. I honestly, personally believe we need, better laws on the protection of witnesses. We also need better laws, more extensive laws on victim participation.
Thank you. And I think we're out of time. Nene, I don't know if you want to ask any questions before we wrap up. That kind of just brings it to the end. Nicely wraps it up in terms of what is needed in our laws and also what is needed in our justice system at the moment.
Mama, thank you, Mr. Gay. Too far. No, Mama, just go ahead. Mr. So, sorry. Mama, just go ahead with the statement from Madi. Go ahead.
Yes.
Thank you.
Madi was.
But Tufa, you're such a face for the young people. Tomorrow's session and future sessions, I want actually the camera on.
Yes.
Oh yeah, totally. I'm just not available to do that today, but tomorrow, happily.
Yes.
Oh yes.
Yes, absolutely, because it will give others the courage as well that they can also come out. Mama, go ahead. Do your thing.
Okay. I have a statement here from Maddie. He was here, but unfortunately, because of the rains, his internet connection keeps going on and off. We used to tease Nancy and say that's Tadwall problems, internet problems. I don't know which provider Gayso is using, but they're very good. We don't want to advertise for them, but it looks like they or maybe we should, Gay, because yours has been, mashallah, very good.
I try going for the best at all times. So I'm bragging now, but but I mean maybe I should. Yeah, we have we have net page at the office and at home.
Okay,
Yeah,
I've had
yeah.
rave reviews about NetPage for sure, and they I think we should approach them because definitely we have problems as well when we have um our co-host in Gambia, people like Nancy, sometimes having problems, and this has been very good actually, very very stable and no problems at all. So definitely, kudos to
Can
NetPage
I
for
say
that.
one good thing about the new law?
Yes, go ahead.
Um, Under the old law, if all you had was the evidence of the perpetrator,
Mm-hmm.
we all know rape normally, happens in private, and of course, outside of the victim, you normally wouldn't have anyone to come in to substantiate what was said. Well, that changed. In fact, in all our appearances before various UN bodies, they kept reminding us because we had a law that said if all you have is the evidence of the victim, as a judge, you needed to warn yourself of how safe it was for you to convict based on that sole testimony. But I think it's traditional, based on beliefs we have that, like, Jigen doing that kind of thing. The
Mm-hmm.
colonialists brought it and we decided to. So at the end of the day, the good thing is that law changed that. So if at the end of the day, all you have is the evidence of just the victim. You can, if you believe in the victim, you find the victim truthful. You don't need to warn yourself. You don't need to caution yourself. You can go
Mm-hmm.
ahead and convict. I think that also is a good provision. One other thing too, if you look at that is Section 7. For those who don't have the law, please go online. I don't like the way people, address things in this country. All you need
Mm-hmm.
to do, go on Google, search Sexual Offences Act 2013 Gambia. So
Mm-hmm.
this is not about Mr. So or Mama or Nene making anything up. You read, satisfy your eyes. You even would see it with the red stamp from government. So it says, now, if all you have is probably the evidence of the victim, you don't have to caution yourself. One other thing I also particularly like about the law is, in our country, because of the way this is treated,
Mm-hmm.
like you would need to talk to your auntie, you would need to talk to your mom, before you have the guts, get their support before you have the guts to report,
Mm-hmm.
So, like, it's not always that it happened today, you have to report instantly. So, if you look at Section 9, it says you cannot use that against the victim, as in saying the rape happened today, report wasn't made until maybe a few days after or a long while after. It's like Section 9. If you just allow me, let me read that. Yeah, let me just read that. This is what it says. It says evidence of period of delay. It says in criminal proceedings at which an accused is charged with an offense of a sexual or indecent nature, the court shall not draw any inference, only from the length of the delay between the commission of the sexual act or indecent act and the laying of a complaint. Meaning, you cannot, for example, as a judge, say, why did it take 2 days for the girl to report? The law now says you can no longer draw inference from that. You can no longer rely on that. That's extremely clear. And again, if you look at Section 10, because it is, I mean, I don't need to say how bad the act is, the attempt is. In fact, Section 10 also says you can now lead evidence on the psychological effects of rape. So it's no longer about you saying, oh, this was what happened to me. If it had that kind of psychological effect, you were traumatized, you're still struggling to get to terms with it, the law allows you to at least give evidence as to how you believe the rape has affected you or in fact members of your family. Because of what happened, I found it impossible. I now find it impossible to stay alone. I now find it impossible to board any taxi. All this is now allowed, as in you're allowed to lead if you appear before the court as a witness. Yeah. So in a sense, a lot of good changes going back 2013. But at the end of the day, we all know what it is like in this country. Good laws, but the problem is always application. You cannot apply if you do not understand, But it's good you guys are having this kind of conversation. Before you defend, before you go against, you need to understand. And I think this is really a very good starting point.
Just a quick question before we close, or some of the comments here. Somebody's asking, Sohna is asking, how about the need for corroborative evidence as required to prove rape? We spoke about the time of reporting not being used against a victim, but what about in terms of the burden of evidence? Because that also is something that, unfortunately, the way rape happens, it's very hard for anybody. I mean, to put it crudely, a lot of women that talk about rape and put it very, very, I don't know if I call it crudely, but put it very raw out there, is that people do not have meters or cameras in their private parts to show evidence. I'm sorry for using those, for being very straight with that. So what is the burden of evidence in terms of rape from that aspect? I think we missed out on that. Thank you so much, Sohna.
The burden is like in all criminal cases. Meaning it is not for the accused to prove his innocence. And of course, like I said earlier, it is now possible under the current law for a woman to rape a man. It is also not a requirement that if the perpetrator is a lady, for her to prove her innocence. So the burden is on the state. And the standard is high, beyond reasonable doubt. Meaning, if there are doubts, remember the law does not say beyond all doubts. For as long as there are doubts, and those doubts are reasonable, they must be solved in favor of the accused person. That's the law. Other than exceptions when it comes to the defense of insanity, as in somebody saying I was insane when I committed the offense. If that is an issue, then it is for the accused person to prove he was sane or insane. But at the end of the day, the bottom line is, if you're accused of rape, you can go to court and stay silent, refuse to say anything. The burden is on whoever is accusing you to prove beyond reasonable doubt that you satisfied the ingredients of the offense of rape as defined in Section 3 of our Sexual Offences Act.
Okay. And Nundu also said something about the mandatory reporting provision in the Children's Act, that it should be more specific and not as general, because it should actually make it mandatory for parents, teachers, social workers, medical officers, and those who have direct contact with the children to report these cases as well, because at the moment, the general nature of the provision makes reporting very poor. I think we touched on that here. So let me just read what Maddie has to say as well. Where's Maddie again? So Maddie said, unfortunately, because of the rain, he keeps switching to both two providers. I won't name them, but it hasn't been successful. So I think we can agree that NetPage is the way to go.
Tell Maddie to do better.
Yeah. So he said, thank you to Gay for this wonderful explanation. I can't agree more. Indeed, the Sexual Offences Act is groundbreaking, but it needs improvement. For me, speaking from a rights perspective, I think the act is only focused on rape, but ignores the broader issue of sexual offenses. This is about sexual harassment. We did not even touch on that. Maybe we'll have another show where we also go into those issues. The incidences of sexual harassment in our homes, streets, markets, workplaces, and everywhere is huge. That must be addressed. Secondly, the act focuses mainly on the female. The language of the law speaks to only rape against girls and women. I think we also say that it speaks to rape, that women can also perpetrate rape. Rape against the male is not quite explicit. This should be addressed. Thirdly, the law did not address the issue of false rape accusations. This must also be addressed in order to prevent it, which can only help women better as any incidents of false accusation, if confirmed in court, goes against women in this kind of patriarchy, the society that we live in. And finally, the law did not address marital rape and rape within partner relationships. These kinds of rape are also common. This must also be addressed. Wives, girlfriends, concubines, mistresses, and intimate sexual partners should be protected from abusive boys and men. And that was I wish I could be on the show for more discussion. So that was what Madi sent us from his observations. I don't know, Gay, if you
Yeah.
want to elaborate on his
Mari,
observation before we close.
Mari is my buddy. We have a engagements mostly on the sides. Yeah, but I mean, I think uh, I wouldn't agree, of course, that not enough is said about men. The law is clear. It says, and penetration, and of course, it makes it clear it is no longer penetration using the male female sexual organ. So it is very gender neutral. The law as it is very gender neutral. So meaning if a boy, even a man is penetrated, we remember we said anal and, mouth under coercive circumstances, that would amount to rape. So I think for me that's extremely clear. I don't know, like I said earlier on, of any other country around us that has, English speaking for that matter, that has something similar. I also do not agree with my friend on the law not addressing marital rape. The law has addressed it. Maybe he should say he does not agree with the way it is covered. But the law specifically says all that we said about rape does not apply to married couples. What's that's whether you agree with the conclusion or not is another issue. But the law has specifically addressed it. Remember, I said earlier on, if you have a copy of the 2012 draft that was submitted before the National Assembly, there was a specific provision that prohibited, that also included marital rape. But what came out of the National Assembly was completely different. They decided to drop that, But I mean, why do we have elections? If majority of us begin to think marital rape should be criminalized, why can't we get our National Assembly to revisit that law? All they would need to do, it's not like the draft constitution. They don't need a referendum. All they need to do is just delete subsection 3 of section 3. Section 3, sub 3, yeah. But like I said, as I speak, the law says the law on rape does not apply when,
Married couples.
yeah, exactly, yeah. Yes, Njundu raised some very interesting issues. I was reading. Yeah, we have something in the Children's Act, but clearly, if you know Mr. Drama, he always is very clear, careful of what he talks about. But his issue, which I agree with, is whether even what we have in the Children's Act is good enough. The Children's Act was passed in 2005. It's a long time ago. So now it's our responsibility to make sure we take a look at it, find out the duties that are there, and then take a decision as to whether they need improvements or we need to leave them as they are. Of course, I note his point, but it was specifically on children. And, this is rape in all cases, as in whether there is a duty imposed to rape, to commit rape, to report rape when you are aware of it. That I think was raised, and I think I have addressed it. But please, all the laws I have talked about are available online. The Children's Act. To be honest, when it comes to the legal framework, and we really have some of the best laws you can find. Children's Act was passed in 2005. The Women's Act was passed in 2010. Then the Children's Act amended to include child marriage. The Women's Act amended to include, the ban against FGM. And of course, yes, after that, in 2013, we enacted the Sexual Offences Act. In addition to that, we also have the Domestic Violence Act. I'm not aware of anybody being prosecuted under that act. So all these are super good laws, but they will continue to be meaningless if we don't start using them. If all we do is go on social media and attack each other.
Yes. Definitely. Your final closing comments or remarks? Anything that you feel we maybe should also just touch on before we leave, and also any final comments for the viewers that are listening? Of course, a lot of feedback, very positive feedback actually. Gay, a lot of people also thanking you for the opportunity to add value to this conversation that we're having today, and to educate us about a lot of things that all of us were perhaps not au fait on or ignorant on. So thank you so much for this opportunity that you accorded us today to actually be with us here for this longer time, and really add so much value to the discussion. Any final comments?
Just to thank you and the organizers, of course, the Nene, I think the co-host, and of course, they, even though she called me Gawe, before I was part of the committee that set up the law department, and as I speak, I think I'm the longest serving lecturer there. And before the university, I also did GDTI. So teaching, I think, is a lot of my brothers are teachers. It's in the family. I know little, but I'm always happy to share the little I know. Of course, I'm on social media, very guarded as to what I say, but I have seen some comments, issues, troubling, and I think we can avoid all these misconceptions if we try to find out more about our laws. You would say, yeah, laws here, there, inadequate, improvement needed here, there. But even as it is, even if we apply the laws as there, we definitely would find ourselves in a better situation. Just to encourage your listeners, all Gambians, let's get the full facts. Let's get a full, proper understanding of issues before we start jumping into conclusions. I have seen some comments, some of them crazy, some of them very hurtful. I mean, on all kinds of issues. But our responsibility to make sure these conceptions are corrected. Let us read a bit more. Let us be more civil in the way we talk to each other. I mean, the law, like I said, I've seen a lot of a lot of people who commented saying, of course, the law is progressive, but the law would remain as progressive as we want to, provided we continue to apply it. Let's look at it, let's understand it, and we know our representatives all owe us a duty to uphold the law. Let's hold them accountable. If we feel what is happening falls short, we really need to hold them accountable. I mean, just last week, my office did a case against Sierra Leone on behalf of a woman who was raped. We were able to get her a few $1,000s. I mean, of course, that would in no way replace the kind of harm she suffered. But at the end of the day, we looked at the law, we realized Sierra Leone fell short. And I will encourage all your listeners to start doing that. Let's understand the issues, particularly the legal angle, before we jump into conclusions. Let's stop confusing each other.
Definitely. Thank you. You have a student or a former student here, Mariam Jai Kaira. She says thank you from one of your former students, and I think we've
I
all
see
been.
a few of them.
I think we're all better off today. Thank you to Modu Boch also for sharing the Sexual Offences Act 2013. If you don't know where to find it, it was linked on the page. I'm taking it off now, but you can also
Can you
find
tell
it.
him to also include the Domestic Violence Act? Is also a very good law.
Yes, we will also include that. In fact, I'll do a document that we can share on the page so that people can look at these acts and read to be able to understand some of the, like you said, the rules and the regulations that definitely we should understand before even commenting on some of these issues. I have to also thank Nyune si Olof Pechum Lir Bunehe Ndeja Japa Simbagabi. And when I say that, I mean that the people that are behind doing some of the work, the likes of De Jobate, the media group, Fatu Baji, and everybody that's also behind doing a lot of crucial work, helping with research and everything that we do. I always say that when we work together, we're better off together, and that's my and it really shows in the quality of what we're able to talk about and what we're able to produce. So I thank everybody who is part of the media team and at the back. Nene, also, if you have any before we go on.
Mama, you and everybody in the back, like you said, have done amazing work. Mahdi, is it Fatu Baji? The whole list. You've just got to list everybody at the back. I think they are doing an amazing job because I don't know everybody in the team too far. Everybody has done an amazing. So if you know all of them, I think it's important we say all their names so that everybody's credited for an amazing production. The productions obviously will continue until the end of the month, I think, and a little bit beyond, with different topics coming on throughout the workshop week. Yes. But thank you, Mama. Thank you, all of you, for being so strong. I think this whole thing has brought a lot of trauma. It has triggered a lot of trauma in me because these were the type of insults, the type of horrible things that they have been saying about feminists and women for the longest time, for the past 13 years since we joined activism up to now. And what is so shocking to me is that I thought we were just talking about FGM, when there are deeper problems in the Gambia. This whole rape case has showed that. So I'm thanking you people who are the younger generation. You have a lot of work to do. And thank you. Keep it up. Thank you.
Thank you. Thank you, Ami, for sharing the link. That is the Domestic Violence Act there. I think what we will do is we'll share it as a document or as a whole list of reference documents for people who are interested in reading them. So we'll do that. Once again, thank you to Gay Soul for, again, like I said, adding so much value to the discussion. Thank you to all of you that were watching us from wherever you are around the world. Thank you for your comments. Thank you for your questions. Thank you for making this discussion, elevating the discussion, and being able to have this civil discussion and this space for, as I said, elevating the conversation to a level that is at least, how do you call it, a teachable moment for all of us. So thank you once again, Gay. I thank you all of you for joining us. We'll be back tomorrow with another topic and, of course, looking at other areas. And we will continue, of course, to do this because it is also our responsibility, all of us, to have these discussions, sometimes these difficult conversations, but to try and have these conversations so that we're all better off, hopefully, at the end of the conversation. Thank you so much once again. Yes.
Can you also add the Women's Act to the list?
Yes, I will add the
Women's Act. Yeah, I think it's important.
I'll share it as a reference document, all of it.
Please. Thank you.
Yes. All right.
Thank you. Thank you all. Thank you.
Thank you.
You hide behind walls of Jericho. Your lies will come tumbling. Deny my place and time. You squander wealth that's mine. The light will shine so brightly it will blind you. Because there's something inside so strong. I know that I can make it. Though you're doing me wrong, so wrong. Before that my pride was gone. Undo. Something inside so strong. Oh, something inside so strong.
Maricham, thank you. Amisise, Omar Bun, thank you so much. Babu Kanyan, thank you. Njundu, thank you so much. Coach Pasamba Jau, thank you to all of you. Absa Samba, thank you so much. Nene, yes, you did a fantastic job. Ahmed Fofana, Mary May, thank you to all of you. And my dear sister, Amisise.